Hello, everybody. We are ready to go live. I see people are still joining the webinar, but I think we'll get started in any event. Look, on behalf of GLA and Company, I'd like to introduce the team today with respect to an important topic: personal data privacy regulations and developments in Saudi Arabia, UAE, and Kuwait. Really hot topic these days. My name is Alex Saleh, and I'm the managing partner of GLA & Co. GLA & Co. is a regional law firm with full practice areas with offices throughout the GCC and Egypt. At the current time, we have over 80 lawyers between the GLA and the Habib al-Mullah Alliance. As a lawyer who has now spent over 30 years in the region between Kuwait, Bahrain, and Dubai, I'm constantly amazed at how our legal regimes in each jurisdiction have grown and developed during this time. I know everyone who knows me is probably tired of hearing my story that when I arrived to the GCC back in the mid-90s, each jurisdiction here only had 3 business laws to review: our civil code, the company's law, and the commercial law. I used to call it the wild, wild east, as foreign companies would ask me, can we structure the deal this way or that way? Do we need government approval for this action or that action? And we would just do it. We'd paper it and we'd be done. However, starting in the last 10 to 15 years, with the last 5 years seeing the greatest development, each jurisdiction has revamped itself by establishing or reorganizing key regulatory bodies that are necessary for a modern-day economy. As a starting point, most of these regulatory bodies are there to safeguard various constituent groups within a jurisdiction. Hence, we've seen the capital markets authorities develop to protect small investors, tougher consumer protection laws to protect consumers, tougher merger control laws to protect the market from monopolies, and such. And with today's topic, tougher laws to protect both the data of the state and individuals' data that could possibly be used in improper ways. As a result of these regulatory developments throughout the GCC, I personally felt there was a need for a new type of regional law firm to develop. One that had talent in each jurisdiction that could talk and have conversations with local regulatory bodies on these important topics, and at the same time advance clients' interest in a way that did not violate the policies that were being put in place to protect the relevant protected class. Now, with respect to today's webinar, we have 4 rising stars with GLA & Co. that will be presenting material on the 3 jurisdictions in question regarding personal data privacy, namely Faraz Kademsi, Hagi Taha, Yusuf Al-Amli, and Asad Ahmed. At this time, I'd like to introduce Faraz Kademsi, who will be moderating today's session. He's head of our data and privacy and based in Dubai, but handles the region. I first met Faraz about 15 years ago. We hit it off when we talked that we were both from Georgetown Law School, although I think I may have graduated a year or 2 before him. Just joking, Faraz. Anyway, I've been Faraz's outside counsel from this time, from when he was with Cerner to when he was Middle East counsel for Uber and later counsel for IBM. This background in the Middle East has really primed him to take a lead in this particular practice area. He was very tough on me as a client, I have to say, so I got him back by bringing him into GLA. In any event, in the past 17 to 18 years in the region with key tech companies, it's given him a lot of insight on this important topic as it's developed, and the other individuals here will be talking about their various jurisdictions as well. So without further ado, I present Faraz.
Thank you, Alex, for that kind introduction. I want to thank everyone for taking time out of their schedule. I know, having been in-house for over a decade, it's not easy to get to these, and so we appreciate everyone joining us for this webinar, which we hope will be informative and useful to you as you evaluate and navigate your understanding and compliance in these jurisdictions, Saudi Arabia, Kuwait, and the UAE. We also hope this presentation will highlight the importance of these laws as you review your existing policies so that you avoid any pitfalls in the future. In our audience, we have a mix of attendees, from those wanting to learn more about the basics on the personal data privacy laws in these jurisdictions and those who are bona fide experts in the field. So this presentation does address some of the basics and most frequent questions that we receive from clients that personally I asked when I was in-house. on a regular basis. At the end, we will focus a bit more on compliance with the Saudi PDPL, which is looming and the grace period lapsing in September. So we have a bit more of a focus there on best practices to prepare for that. As Alex mentioned, I've worked at several companies in the region where data is not just a compliance afterthought. Instead, data is at the very foundation of how some of these companies were built in the first place. And what I mean by that is that data, of course, is the asset. So how these companies treat and process personal data was truly at the core of their being and their interaction with the public at large. In the case of Cerner or Oracle, health data is at the very foundation of how that company monetizes its offerings in the electronic medical space, medical record space. It's at the forefront of how preventative and predictive medicine is being formulated. As many of you know, health data is also a special category under the general field of personal data. And it is quite literally its most important asset when it starts to develop new products, especially when those data sets are what will be used in how AI is used and intervenes in the future. At Uber, I can personally attest that data was at the heart of every decision, from how marketing dollars were spent to how pricing was set. And if you've been a rider in an Uber, you know that the pricing data sets can be very important depending on the time of day you're requesting one. Externally, data sharing at Uber was a big part of the policy mandate in terms of engagement with municipalities and the public at large. And that ranged from sharing of anonymized aggregated data sets in urban planning to sensitive personal data sharing and investigations with law enforcement. It's really incredible to see how some of those data sets are being used today in urban planning projects like metro lines and where to build and conversely not build parking structures. At IBM, data and its protection were at the heart of its reputation as a market leader and market maker in many ways in the field of cybersecurity and responsible handling of data. From the ethical use of data in the field of artificial intelligence to advising sovereign states on best practices on how to protect and preserve data critical to the state, IBM really stakes its reputation as being a thought leader in this space. Joining me in this webinar are three of my colleagues who will give us a primer on the various personal data laws and regulations that govern the United Arab Emirates, Saudi Arabia, and Kuwait. They also regularly engage with the regulators and engage with clients on these issues. My colleague Hagi Taha will cover Saudi Arabia. Hagi has more than 16 years of experience of visiting clients in Saudi Arabia and Egypt, specializing in corporate M&A, capital markets, civil, commercial, and employment laws. He's also participated in several major transactions in the region, and he regularly advises clients on the regulatory compliance requirements of the PDPL as it comes into force. My colleague Yusuf Al-Amli will cover the United Arab Emirates. Yusuf is a partner at GLA, and he is duly qualified in both the UK and Egypt. Yusuf has advised clients on complex corporate and commercial structures and transactions in relation to JVs, corporate restructuring, M&A, equity capital markets, and commercial transactions. Yusuf has also advised on several matters related to anti-money laundering, cybersecurity, and data protection in the UAE. My colleague Asad Ahmed will cover Kuwait. Asad heads our competition and antitrust department, and he regularly advises clients throughout the region on competition and antitrust matters, including regulatory filings. Asad has extensive background in advising on the marketing of securities, corporate governance issues, policies, and regulatory compliance. Due to the increased demand, Asad has expanded his expertise in advising on data protection regulation in the region with a focus on Kuwait and interaction on data inquiries with the regulators such as Citra. All three of my colleagues are in regular contact with the relevant regulators, as am I. And so that's obviously something else that we advise clients on. As a reminder, we'll be taking questions during the presentation, which we will try to address at the end, but we will do privately for sure, and you can put those in the chat box. We'll try to do so, but there may be some time constraints. Now that with that out of the way, let's get into the beef of this. We thought we'd start the presentation with an overview on the major laws governing the space and the regulators charged with oversight. There are several data laws and regulations on the books across the region, and we are covering in this webinar. We have additional regulations imposed by specific ministries which layer on top of the personal data protection regulations. The primary focus today, though, will be on the primary national pieces of legislation affecting personal data. In addition, in the case of the UAE, our primary focus beyond the mainland will be on the DIFC and ADGM. So with that in mind, let's start the presentation off with my colleague Hagi, who will cover the major laws in place covering personal data privacy in Saudi Arabia. Hagi?
Yeah, thank you, Alex, and Firas for the introduction, and thanks everyone for joining us. At the outset, the main law regulating personal data in the Kingdom of Saudi Arabia is the Personal Data Protection Law, together with the implementation regulation, which came into force on the 14th of September 2023. Data controllers, however, have a one-year grace period until the 14th of September 2024 to comply with the law. The law mainly covers processing of personal data that takes place in Saudi Arabia and related to individuals residing in the kingdom by any means, by any party, even outside of the kingdom. So the law is actually designed to apply extraterritorially. So it's important that companies comply at a global level when they are processing data related to Saudi Arabia. Also, specific regulations are issued to govern data transfer outside of the kingdom. The Saudi Data and Artificial Intelligence Authority, known as SADAYA, is the regulatory body that is empowered to supervise and enforce the implementation of the law in Saudi Arabia for at least the first 2 years following promulgation. Consideration will be given to transferring supervising regulation and the application of the law to the National Data Management Office, which is the regulatory subdivision of SADAYA. Going to Asad to inform us about Kuwait as well.
Yeah, thanks, Hagi. I appreciate it. With respect to Kuwait, of course, Kuwait has to always be different, just a little bit different. The current landscape is in a great area. Initially, Kuwait Decision Number 45 of 2021 regulated the data privacy protection along with its privacy policy. However, just a few months ago, Kuwait limited the scope of this DPPR to the telecommunications sector for only those entities licensed by the Communication and Information Technology Regulatory Authority, which is CITRA. This was done pursuant to Law Number 26 of 2024. With that being said, the Electronic Transactions Law under Law Number 20 of 2014 and the implementing regulations regulate the protection of private and public data of electronic records, such as signatures, documents, and payments. The E-Transactions Law applies to electronic records, documents, and information linked to civil, commercial, or administrative transactions conducted via electronic methods. With respect to cybercrimes law, Kuwait does have a law number 63 of 2015, which imposes fines and penalties in relation to the illegal dealing or possession of personal and governmental data. And as referenced, CITRA and the Central Agency of Information Technology, CATE, are the primary regulators responsible for overseeing data protection in Kuwait, pursuant to the E-Transactions Law and the current DPPR. Furthermore, the Electronic and Cybercrime Combating Department, the ECCCD, is a specialized department within the Ministry of Interior in Kuwait that is responsible for enforcing Kuwait's cybercrimes law and investigating cyber-related crimes. That is it for Kuwait, and I'll hand it off to my colleague Yusuf for UAE.
Thank you, Asad. Hello, everyone. So talking about the UAE has a complex legal framework when it comes to data privacy. So what I mean by that is that on the federal level, you have the primary legal framework for personal data protection, which is the federal law of 45 of 2021, which came into effect on the 2nd of January 2022. This federal law extends across the UAE, but excludes entities in free zones and specific sectors, such as the government data, security, judicial authorities, health and banking and credit sectors. Additionally, sector-specific regulations include the federal law of 14 of 2018, which addresses the customer data protection in the banking sector. You have also the federal law 3 of 2003 for telecommunication consumer data, and you have the federal law number 2 of 2019 concerning the confidentiality of health-related information. In prominent free zones like the DIFC, or what we call the Dubai International Financial Center, and the Abu Dhabi Global Market, or ADGM, distinct data protection law applies. So in the DIFC, you have the DIFC law number 5 of 2020, which applies within the DIFC. And then within the ADGM, you have the ADGM data protection regulations of 2021 in the ADGM itself. These free zones, whether the DIFC or the ADGM, are governed independently by their respective data protection authorities. Now, when it comes to the regulatory landscape, you have regulatory oversight across these very jurisdictions, and they are managed by several bodies. What I mean by that is that you have the UAE Data Office for the onshore PDPL law. You have the Office of the Commissioner of Data Protection in the DIFC, and in the ADGM, you have the ADGM Office of Data Protection. Then you have the central bank for the banking sector, and you have the Telecommunications and Digital Government Regulatory Authority for the telecommunication sector. And with regards to healthcare, you have the health authorities within each emirate that oversee the protection of the patient data. One last point to mention is that with regards to the federal law, that despite the implementation of the PTPL law at the federal level, the expected executive regulations following its issuance was expected to be enacted by the 20 September in 2021, but it has not been published yet, which leaves certain aspects of the enforcement and compliance in limbo. Having said this, back to you, Firas.
Thanks for that, Yusuf. I think we've discussed the issue of the executive regulations not being issued. I think a lot of people joining us today are waited with bated breath on that. Been waiting for quite some time for that. And thank you, Asad, for reminding us of the uniqueness always of Kuwait and its laws and regulations. Well, now that we've gotten sort of the high level overview of the personal data laws and the regulators, let's get into some of the specific questions that we get from clients all the time. This question of consent is a big topic when it comes to data processing, and of course the exceptions to when you need consent, particularly from companies dealing in certain sectors or companies dealing with large volumes of data sets. Consent usually involves being informed, freely given, consent that's specific and unambiguous. You also got concepts related to when you need explicit consent versus informed consent versus valid consent. And as I stated before, the exceptions. So with that in mind, the second question, when and what type of consent do I need from a data subject under the law, is a popular question. And we'll start off with my colleague Hagi to cover this topic in Saudi Arabia.
Thank you, Firas. Well, there are several circumstances where consent is required and at a various point as it relates to personal data. For example, consent is required not just for disclosure, but for collection and processing purposes. The implementing regulation provides further detail in respect of consent, including information on circumstances where consent must be explicitly obtained and documented, and the ability of the data subject to withdraw the consent at any point of time, and information on obtaining consent from those without legal capacity, such as minors. Generally speaking, Article 5 of the law prohibits the processing of personal data without the consent of the data subject, except in specific circumstances. It also prohibits changing the purpose of processing without the consent of the data subject. Article 11 of the implementation regulation specify the condition of the consent. In this regard, Article 6 of the law and the implementing regulations lays out 5 exceptions where consent is not required under the law. The first, if the processing would achieve a clear benefit and it is impossible or impractical to contact the data subject. The second, three, sorry, guys, can you hear me?
Yeah, yes, good. Continue, please.
Yeah, I'm really sorry for the disconnection. Yeah, I'm saying actually that there are only 5 exceptions where consent is not required under the Saudi PTPL. The first, if the processing would achieve a clear benefit and it's impossible or impractical to contact the data subject. The second, if it's required by law or prior agreement to which the data subject is a party. 3, if the controller is a public entity and the processing is required for security or judicial purposes. 4, if the controller is collecting data for scientific research purpose while having taken the necessary steps within the law. Number 5, if the processing is necessary for the legitimate interest of the controller or other party, provided that the rights of data subject are not prejudiced. However, of course, this does not apply in the case of sensitive personal data as defined under the law. It's important to note that data subjects can also withdraw their consent to process data at any point of time. So companies must provide a mechanism to do this in a clear and efficient manner. Consent is also required where the data controller wishes to process personal data for purposes other than those for which consent was originally obtained. Back to Asad, and let me know if anything is actually missing in this respect.
Thank you, Hagi. I appreciate it. With respect to Kuwait, we're going to quickly just remind you that there's the e-transactions law and the DPPR because of the current gray area, right? So under the e-transactions law, Article 4, individuals are generally not obliged to deal by electronic means except with their consent. And it's important to note that consent may be inferred through affirmative conduct. Article 32 of the e-transactions law states that when collecting personal data, including but not limited to personal data and data related to individuals, professional affairs, social status, health status, or financial status, government authorities, public authorities and institutions, companies, non-governmental entities, and their employees are obligated to secure individuals' consent, as well as state the purpose behind collecting such data. Under Article 32 and 35 of the e-transactions law, entities must also ensure that consent is obtained when conducting any access, disclosure, sharing, or processing of any collected and stored data. And entities are obliged to ensure that such activities are conducted by lawful means and be limited to the stated purpose, provided that data owners at the time of the data collection or at the time of conducting these activities. The DPPR under Article 2 and 4, licensees must secure user consent prior to collecting and processing their personal data and must specify the purpose for data collection and processing both before and during the provisions of services, as well as after the termination of services. So that's it for Kuwait with respect to both these aspects, and I'll hand it off to Yusuf.
Thank you, Asad. To remind everyone, when it comes to UAE, you have 3 different jurisdictions, which are mainland, DIFC, and ADGM. And each jurisdiction has its own separate data legislation, which applies only to that jurisdiction specifically. So starting with the federal or the mainland, you have on the federal level, you have, again, the Personal Data Protection Law, the PTPL, which outlines stringent requirements for obtaining data subject consent, specifying that it must be specific, informed, and unambiguous. This means that the consent must be clearly linked to a particular data processing activity with data subjects fully informed about the purpose of data processing and the identities of the data controllers. In the DIFC, on the other hand, and the ADGM, both the DIFC law and the ADGM regulations echo these requirements and add that consent must be also freely given, ensuring that it is voluntarily provided without any coercion. Both the DIFC and the ADGM outline several exceptions to the need for consent, and these exceptions allow for data processing without consent in situation such as fulfilling public interest obligations, processing the data that the data subject has made publicly available, legal proceedings, medical purposes, public health safeguarding, archiving for scientific or historical research, and necessary operations related to employment, social security, or contractual obligations. Additionally, data processing may proceed without consent if it is required to comply with other legal obligations under the UAE law. In terms of enforcement, both the DIFC and ADGM provide that processing personal data without the data subject's consent is permissible under several lawful bases, such as when it is necessary for the performance of a contract or to fulfill legal obligations, or also to protect the vital interests of the data subject or others. These regulations also specify conditions under which data processing can be justified by the legitimate interests of the data controller, provided, however, such processing does not unduly infringe on the privacy and rights of the data subject. Furthermore, when it comes to ADGM or the DIFC, both jurisdictions uphold the data subject's right to withdraw their consent at any time, emphasizing that the withdrawal process should be as easy as the process for giving consent. Like, for instance, in the DIFC, data controllers are required to comply with a withdrawal of consent within 30 days, highlighting the importance of responsiveness and compliance in data protection practices. Overall, the regulations stress that consent should not be inferred or assumed by default, but rather it must be an explicit, clear, and voluntary act, establishing a framework that prioritizes clear communication, transparency, and the autonomy of the individual in personal data processing. One last thing to mention is that we are still waiting for the PTPL executive regulations to know the rules that would apply federally when it comes to consent. So things are still unclear until the executive regulations are out. Back to you, Firas.
Thank you, Yusuf. I know that refrain will be popular today, awaiting the executive regulations and the ambiguity that comes with that. I know there's a lot of anxiousness for people who are attending who cover the UAE, and we'll talk about that a little later when we get into the Saudi PDPL. The next question relates to data protection officers, and we get this query a lot from clients. The promulgation of various data protection laws in the personal data space imposes many obligations on companies as they come online in each jurisdiction, not just in these three jurisdictions, but Brazil, obviously when the GDPR came online. Sometimes these obligations are redundant or similar in nature, and so the changes are incremental in terms of what you need to do. One of the changes where you can see a direct cause and effect in terms of operational and financial impact is an obligation to have a DPO. Is that DPO requirement jurisdiction specific? Where do they need to sit? What nationality must they be, et cetera, et cetera. So in this context, we're going to go into each of these jurisdictions to kind of understand what are the rules, even where there's not specifics on when do we need to appoint a data protection officer, and what does that person or process need to look like. So with that, I'll hand it over to Hagi to start off on Saudi Arabia.
Thank you, Firas. First of all, Article 32 of the implementing regulation requires data controllers to appoint a data protection officer, a DPO, in certain circumstances. This includes where the data controller is a public entity that provides services involving the processing of personal data on a large scale. Also, where the primary activities of the data controller consist of processing operations that require regular and continuous monitoring of individuals. And 3, where the core activities of the data controller consist of processing sensitive data as defined under the PTPL. Despite the fact that the implementing regulation specified the scope of work and duties of the DPO, however, it does not specifically mention if the DPO must reside in Saudi Arabia or to be of a specific nationality. As a matter of practicality, if you are a multinational company operating in a jurisdiction where the handling of the personal data is regulated by one of the major regimes, for example, the GDPR or the CCPA, you likely have a DPO team in place. However, the need to appoint a dedicated DPO for Saudi operation will be based mainly on the nature and the volume of the data you process. Moreover, the way you currently handle data should inform your decision in this regard. For example, even if you are processing data in a whitelisted country, or the adequacy of data transfer abroad is in line with the Saudi law, there may be practical and operational reasons to why you might elect to appoint a dedicated DPO based in Saudi. For example, you may appoint like a regional DPO in Saudi to actually cover the GCC area, or because your current DPOs are not familiar with Saudi laws and regulation, or actually for language capabilities. Back to Asad.
Yeah, thank you, Hagi, for that. I appreciate it. With respect to Kuwait, this is an easy question to answer. Presently, there is no requirement to have a dedicated DPO for entities operating in the private sector. Having said that, we do recommend that clients based in Kuwait or those doing a heavy amount of business in Kuwait add monitoring of compliance with Kuwait data privacy laws and regulations to the list of activities that legal, privacy, or regulatory compliance teams within these entities already perform. This is good and practical business practice, and as we've seen in other jurisdictions, it is not outside the realm of possibility that Citra, the regulator here, adds this as a future requirement. So staying ahead of the game operationally would be in the best long-term interest. In addition, the DPPR, the current DPPR, which is limited in scope, does make reference to DPOs for licensees and requires certain information about these DPOs to be disclosed to Citra in the event of security breaches and when licensees are maintaining processing records. This implies that the DPPR imposes an obligation for licensees to appoint DPOs as part of their operations. And that is it for Kuwait. I'll hand it off to Yusuf for UAE.
So contrary to what Asad said, this is not an easy question when it comes to UAE. And sorry for that, Asad. But again, we have three jurisdictions. So on the federal level and under the federal PDPL, the appointment of a data protection officer, or what we call the DPO, is mandatory in circumstances where data processing involves high-risk activities, such as, for example, the use of new technologies or large volumes of data, as well as when there is a systematic and comprehensive assessment of sensitive personal data through means like profiling and automated processing. The specifics regarding what constitutes high-risk technology and assessment standards will be detailed in, again, the executive regulations still to come out. It is advised, however, that any company dealing extensively with UAE data, particularly those managing large volumes or sensitive personal data, should appoint a DPO who could potentially oversee data protection responsibilities in multiple jurisdictions, depending on operational needs. On the other hand, one important point to highlight is that in the DIFC, the law mandates a DPO for entities engaged in systematic high-risk processing activities, and the commissioner may require other entities to appoint the DPO as well. Similarly, in the ADGM regulations require DPO as well for public authorities, excluding courts in their judicial capacity, and entities whose core activities involve large-scale monitoring or processing of special categories of personal data. Finally, the role of the DPO in general in the UAE, it includes monitoring compliance with applicable data protection laws, advising and informing the data controllers, processors, and their employees about their legal obligations, and also serving as a contact point for the regulatory authorities, ensuring that data protection measures are upheld across the board. Having said this, back to you, Firas.
Thanks for that, Yusuf. Just as a side note, we are monitoring the questions, and obviously we're in the middle of a presentation, so that was part of the reason why we said we would try to get to them as they're rolling through, and I have been trying to do that. So keep them coming, and to the extent that I can respond to them while we're doing this, I will do so. Otherwise, we will collate them and get some responses back to everyone. On to the next question, which relates to another popular topic, depending on if it's happened or when it's going to happen, and that relates to data breaches. I spent a lot of time in-house, as I documented earlier. And when you're in-house, you have a lot of balls in the air. So sometimes tackling an issue that has not yet occurred is sometimes the last thing you want to be doing, especially when you've got to cover so many different things. But I think when it comes to compliance, a big part of your preparation is not just knowing the law, not just getting the opinions and going to outside counsel like GLA to get advice on this, but it's also knowing what to do when you may have broken the law. It's also a big part of your BCDR process, knowing who to contact, when to contact, who to contact. Obviously, we live in a world where a data breach in many ways is not necessarily a question of if, but rather when. Many clients will also inevitably fall victim to a hack or other cybercrime that results in a data breach. So the question that always pops up is, what do I do now? Sometimes this can be a difficult assessment because diagnosing the nature of the breach can also be burdensome and a technical task. Then there's the issue of whether the breach was your fault, so to speak, or a third party. There's also the issue of reputation and communication and the immediate aftermath to data subjects affected and the public at large to consider. So with that in mind, the question is, if a data breach does occur, what do I do next? And let's start with Saudi Arabia.
Thanks, Firas. Let me clarify this. At the outset, Article 20 of the PTPL does specify that the controller must notify both the competent authority and the individuals affected of any breach, damage, or illegal access to personal data. Although the implementing regulation specifies what information should be communicated in the case of a breach. However, there is no specific obligation of public disclosure. Article 24 of the implementing regulation goes into further detail about the process if there is a data breach. So as a first step, the controller shall notify the competent authority within a delay not exceeding 72 hours of becoming aware of the incident. If the controller indeed was not able to notify the authority within this time frame, it shall provide it as soon as possible, actually with the justification for the delay. The notification shall include 5 main components. The first, a description of the incident, including the time, date, and the circumstances where the controller became aware of it. B, actual or approximate number of impacted data subject and the type of personal data. C, outlining risks, impact of the breach, also involving action taken to prevent or minimize the risks and the plan for future measures to prevent the similar breaches. D, a statement if the data subject has been notified of the breach in accordance with the regulation. And lastly, contact details of the controller or its DPO. As a second step, the controller shall, without undue delay, notify the data subject of a personal data breach with a description outlining the risks and the impact of the personal data breach, also involving action taken to prevent or minimize such risks. It is required that the controller shall keep a copy of the reports submitted to the competent authority. It's important also to note that whatever is required under the law to be submitted to the competent authority does not affect any additional obligation the controller may have to submit according to what is issued by the National Cybersecurity Authority or any laws or other regulation applicable in the kingdom. Back to Asad to inform us about Kuwait.
Yeah, thanks, Hagi. In accordance with the current, again, limited in scope DPPR, licensees are required to implement robust measures for safeguarding data from unauthorized access, loss, destruction, or damage, with protective measures to include encryption, confidentiality practices, and disaster recovery protocols. Under Article 6 of the DPPR, when a personal data breach occurs, the licensees must notify CITRA within 24 hours through official channels. there are three other key aspects or obligations, I should say, that you need to be aware of with respect to data breaches. The notification to Citra should detail the nature and extent of the breach, including the leaked personal data of users, affected individuals, and compromised security levels. Additionally, it should provide contact information for the DPO. And thirdly, the licensee is also obligated to inform the affected personal data subjects about the breach unless appropriate technical and organizational protection measures have been implemented, in which case notifying the data subject is actually not necessary. Cloud computing service providers, CSPs, must notify users of a security breach within no more than 72 hours. They also must have established safeguard mechanisms in place with regards to disaster recovery and risk management. Under the same provision, a CSP must provide its users with the technical means to access the given information and the process by which to amend the same. Exclusive of those two aspects, there may also be an obligation to inform law enforcement, depending on the nature of the breach. For example, a breach that is due to cybercrime may require you to inform the public prosecutor's office in addition to and exclusive of the regulators. And that is it for Kuwait on that aspect. So I'll hand it off to Yusuf.
Thank you, Asad. So the UAE is very similar to Kuwait and KSA in that aspect. So starting with the federal legislation, so under the federal data protection framework, and in the event of a data breach that poses a risk to the privacy, confidentiality, security, or rights of data subjects, immediate action is required. What I mean by that the data controller must report the breach to the relevant regulatory authority without delay, and the data processor, upon discovering any breach, is obliged to or obligated to inform the data controller promptly. Specific notification timelines are set by the different UAE regulations. So under the UAE PDPL or the federal PDPL, for example, it mandates immediate notification, while the DIC law stipulates notification as soon as practicable. The ADGM regulations are more precise and prescriptive, requiring breach notification within 72 hours of awareness, with a requirement to provide reasons for any delays beyond this period. Now, notifications must include, in all three jurisdictions, a detailed description of the breach, contact information for the data protection officer, the likely consequences of the breach, and the measures taken or proposed by the controller to address and mitigate the effects of the breach. However, in cases where a breach poses a high risk to the security or rights of data subjects, in such case, the controller is also required to inform the affected individuals directly. Additionally, depending on the nature of the breach, there might be obligations under the penal code to report to law enforcement authorities, particularly if the breach involves criminal actions such as hacking, for example. Further specifications when it comes at the federal level may be added once the executive regulations of the PTPL are issued. And I know I'm being repetitive on this part, but the executive regulations will detail a lot of information as we expect. Having said this, again, back to you, Firas.
Thanks for that, Yusuf. I think we can add that, record your voice and add that to the end of each of your responses for the UAE. I will say, this does come up. We did have a client recently have an issue, and we were in regular contact with Sadaya in order to report this, and it was a self-reporting issue. Obviously that decision, there's so many things that go into that, right? The comms, the policy, what's the public fallout, who do you need to inform when you have those personal data breaches, including your own internal folks, so when it affects your employees and whatnot. So that this is definitely a hot topic. It's something that we have a lot of experience in all three jurisdictions, working with the regulators, and so hopefully it doesn't happen to you. But again, in the world of compliance, It's almost a question of when, not if. On to the next question. There's also the issue of penalties and deterrence under the law, which serves as a motivating factor to ensure compliance and continuous monitoring of the protections that are in place, that the law is intended to protect individuals and their personal data against bad actors. We have seen the effect that the regulation, oversight, and enforcement has had with major multinational companies operating, in particular in the European Union under the GDPR, where the threat of penalties and enforcement of those penalties has increased compliance standards, has really made it a major focus. And it's not just the threat, but the actual billions of dollars that have been assessed. And these days, it's just not about the law. It's about your reputation and the way that you interact with the public at large. A more secure company is a more trustworthy company, and the people generally want to be doing business with brands that they trust in the first place as a starting point. With that in mind, what are the penalty regimes that are in place in each of these jurisdictions? And we'll start again with our favorite place, Saudi Arabia.
Thank you, Faraz. I totally agree with you, but let's clarify in Saudi. In general, the current law reduced the number of criminal offenses with respect to the criminal sanction for violating data transfer restrictions. However, when it relates to disclosure of publication of sensitive personal data, the law does not just impose finance penalties, it also has the threat of imprisonment. Article 35 of the PDPL specifies that any individuals who disclose or publishes sensitive personal data as defined under the law, either intentionally or for personal benefit, may be subject to a penalty of up to 2 years of imprisonment and or a fine of up to 3 million Saudi riyal. Of course, this is without any prejudice to any other harsher penalty applicable under any other law for the same act. Also, these penalties may be doubled in case of repeated offenses. Other than this penalty, Article 36 outlines like a general catch-all penalty applicable to all violations under the PDPL, ranging from warning up to a fine of 5 million Saudi riyal applicable on every person with a special nature or legal capacity who violates the PDPL. This is again without prejudice to any other harsher penalty applicable under any other law, and a penalty indeed may be doubled in case of repeated offenses. In our view, the wording of Article 36 leaves a lot of room for interpretation, as it did not specify who has a special nature or legal capacity in terms of the violations under the law. Is it the controller? Is it the CEO or the legal representative or maybe the DPO? In all cases, the foregoing penalties and their application are not yet tested due to the recent issuance of the law and the implementing regulations, which is still under study. Back to Asad to inform us about Kuwait.
Yeah, thank you, Hagi. With respect to Kuwait, Citra actually has 3 tools it can utilize depending on the type of violation. So it can utilize the Citra law itself and the penalties under that, or it can utilize the e-transactions law and the penalties under that, or the cyber crimes law, depending again on the type of violation. With respect to the Citra law under Article 66, if a Citra inspection determines that a violation or suspected violation of its laws has been committed, then Citra must instruct the public prosecutor's office to adopt appropriate measures. However, there is some breathing room here. Under Article 63, the board of Citra may accept reconciliation of the violations of its laws or regulations and accept a cash penalty of no less than twice the amount of the fines stipulated in the Citra law before a referral to the public prosecutor's office. Now, such violations include using bugging devices, which is punishable by either imprisonment for no more than 1 year or a fine of no more than 5,000 Kuwaiti dinars and no less than 500. And illegally using a private or public telecommunications network. This is punishable by either 2 years in prison or a fine of no more than 20,000 Kuwaiti dinars and no less than 500 Kuwaiti dinars. under Article 81 of the Citra law. It should be noted that the above described penalties do not prejudice any person from bringing a claim for direct compensation as a result of such actions. Due to the Citra law and Citra regulations being so new, the procedure has yet to be tested with the courts. Now, with respect to the e-transactions law, Article 37 states that individuals who unlawfully access, disclose, or publish any personal data registered in the records or electronic processing system of the entities related to professional affairs, social status, health, or financial status of the individuals, whether registered with the entities or their employees, without the consent of the data subject, may face imprisonment for up to 3 years and a fine ranging from 5,000 Kuwaiti dinars to 20,000 Kuwaiti dinars. In addition, Article 37 states that entities that collect, register, or process any of the personal data stored with them on their electronic records or processing system using unlawful methods or without the consent of the person concerned, or that use the stored personal data for reasons other than those for which they were collected, may face imprisonment up to 3 years and a fine ranging from 5,000 Kuwaiti dinars to 20,000 Kuwaiti dinars. So that's with respect to the e-transactions law. And finally, with respect to the cyber crimes law, it imposes a fine and penalties in relation to the illegal dealing or possession of personal and governmental data. And that is it for Kuwait. I'll hand it off to Yusuf.
Thank you, Asad. With regards to the UAE, on the federal level, the PTPL currently does not specify penalties for non-compliance. However, administrative penalties will be determined by the Council of Ministers and detailed in the forthcoming executive regulations to be issued by the UAE Data Office. But beyond the PTPL specific penalties, the UAE's penal and civil codes already establish fines and imprisonment for data-related offenses. Such as, for example, the unlawful disclosures, cyberbullying, hacking, fraud, identity theft, and spreading false information. For example, fines for cyberbullying can reach up to 500,000 dirhams with imprisonment of up to 3 years, while hacking can incur penalties of up to 3 million dirhams and 10 years of imprisonment. Additional laws such as the Federal Law Number 2 of 2021 enhance penalties for cyber crimes. This is the legislation related to health data, including those committed via social media, and so any cyber crimes, including those committed via social media, and allow for seizure of devices used in such crimes, are one of the penalties that are imposed. In the DIFC, on the other hand, the data protection law caps administrative fines at $100,000 per breach by data controllers or processors, with discretion for higher fines for severe violations and potential compensation awards by DIFC courts for material harm to data subjects. Notification failures are fined up to $25,000 in the DIFC. On the other hand, what's interesting in the ADGM, non-compliance can attract fines up to $28 million per offense, which with each case being investigated individually by the Commissioner of Data Protection, who determines the final penalty not exceeding this limit. Overall, these regulations underscore the stringent enforcement and significant financial implications for data protection violations within the UAE, whether mainland or major financial hubs. Back to you, Firas.
Thank you, Yusuf. I think a lot of you are wondering perhaps why our colleagues are presenting as opposed to me as being the head of our data and technology practice. I've been monitoring the questions, and so hopefully you guys have gotten some real-time answers to the best of our abilities here. We'll do our best to respond offline to some of the more complicated or follow-up queries to make sure that you guys get some answers to some of these very important questions. I want to thank our colleagues, my colleagues, for showing off our depth of knowledge in these areas, and I'm going to focus now on our last topic, which is a bit of a deep dive as we get into Saudi Arabia. We have a lot of people on the line who are have a lot of operations in Saudi Arabia or are looking to get into the Saudi market. The Saudi PDPL, which did come into force but has a 1-year grace period, which is set to lapse in September 2024, it does still have some ambiguity. And so for those of us that are tasked with ensuring our organizations are compliant, ambiguity can cause a lot of anxiety and trepidation. I think I spoke with one client and we were talking about some of the ambiguity, and I always kind of looked at ambiguity. You can look at it half glass full, half glass empty. Sometimes ambiguity will allow you to drive a truck through an exception or through an interpretation. I think the key is to look at these things in good faith. The collective anxiety of the unknown is well placed, though, when it comes to the fact that SEDAIA only recently released some additional amendments in March for public comment, and some of the key items like the SECs and the whitelist have not yet been issued in Saudi. The good news is that when it comes to Saudi Arabia, the history of the government and the regulators, particularly SEDAIA and MISA, working together with private industry to resolve issues amicably is strong, and it is there. And I can attest to this personally, having engaged with the policymakers and the regulators. There is a desire and a commitment to producing best-in-class regulations, which is why you see a lot of the same provisions that you've seen in the GDPR and the CCPA, et cetera, replicated in the Saudi law. And that's by design. They want us to have laws and regulations that are both fair but take into account business input, but also at a base level protect Saudi Arabia, its residents, and people in general, their personal data when they're operating in Saudi Arabia or extraterritorially. In many ways, having that best-in-class regulations means that the job of evaluating compliance is more incremental in nature, which is a good thing. I think it doesn't mean that you don't go through your processes and audit your current state of affairs, but it does mean that the job is made a bit easier. So what can we do as gatekeepers to ensure that we are as prepared as possible as the PDPL grace period lapses? These are not meant to be exhaustive, but they are meant to be indicative, and they are meant to provide you with some of the things that you can be doing now. And I know that's a lot of legal speak for one sentence, but it is important to understand that they're still working through some of these issues. The good news is that they're addressing them, and you can see that with the amendments that came out in March. I would say a lot of our clients are already operating under the GDPR regime, and so a review and audit of your data governance and operating model will be something that already exists for most clients. For other clients that are regionally operating or only operating in Saudi Arabia, this will be a bit more of a heavy lifting, and where you're going to need outside advisors to help. And obviously, we GLA are well placed to do that if and when that comes up. There's also the topic of providing training for your key employees and management. For example, this seminar, right? Making sure that, or this webinar, I should say, where people are attending and understanding and reading up, and internal and presentations. We're constantly asked by clients to prepare that, either where we provide it directly or provide it to in-house counsel, who then provides it to the key managers. The key employees we're talking about are people who are in a capacity to manage data and data sets, either as your chief privacy officer or your DPO, or in key areas like HR, and obviously management at the C-level, making sure that people get the messages out that we need to take data privacy compliance seriously. In the context of the US, for example, you won't see an FCPA presentation where at a properly run multinational where the CEO or a C-level person is not giving the initial speech or providing, signing off the letter of compliance. And so it's similar in this area. You want to show that your key managers, your top level managers, have received training and are at the forefront of this. That's part of the back end of this. When something does happen and the regulator is auditing what you did to mitigate, you want to be able to say, hey, look, I gave training. I made sure that my key managers were at the forefront of this, and continuously monitoring this issue. I think one of the things that you can do as well is if you already have a DPO, add Saudi Arabia to their responsibilities. If you have a DPO structure, right now we don't know, and it's highly unlikely, but we don't know for sure if the DPO will need to sit in Saudi Arabia or be of a certain nationality, etc. But you can already have within your DPO structure, have somebody dedicated to learning and understanding and being responsible for compliance when it comes to Saudi Arabia. Again, if you're not a multinational, this becomes a bit more heavy lifting. If you're only operating in Saudi Arabia and you've never been operating under the GDPR or under CCPA or any of these other international data privacy regulations and regimes. You can also perform a technical data mapping exercise and a gap analysis. That gap analysis, again, if you're a multinational, this will be a bit of an easier task if you're operating under GDPR because you've probably already done it. And you've also got the privacy impact assessment that you can review as well if you've already conducted that. Now, this is a thing that you have to be vigilant on. So it's not a one-time thing. It's something that you'll have to do, and you'll need outside advisors to help you with that as well. And again, GLA is well positioned to assist with that. And again, even though the Saudi PDPL, the regulator has not issued the SECs, you can go ahead and start reviewing your own standard contractual clauses, your BCRs, and your data sharing agreements or your data processing agreements that are already in place internally and externally. I know we've run over a little bit of time, so unfortunately we'll not be able to answer these questions live, but I have been doing that on a rolling basis, and we will get the questions collated, and we promise to get responses back to you. We are, of course, a law firm that's well positioned to assist any of our clients, anybody attending this, in reviewing and advising on your existing processes and ensuring that they're in line with the law. And we welcome that. And we will, you can obviously reach out to myself or any of my colleagues to assist with that. And we'll get contact information out to everyone. I'd like to thank you for your time and in advance for your questions, which we will be addressing offline. I'll hand it over to our managing partner and our fearless leader, Alex Salah, to close out our webinar. Thank you again.
Well, that was a wonderful presentation. Saying that comes to mind listening is Rome wasn't built in a day. These are regulatory bodies that are still getting their feet on the ground, and they've issued things, and there's going to be more regulations to be issued. And that's okay. And that's how things work. It's a process. They issue, we work with them, us and other practitioners, and then new regulations come out. And sometimes you have to revise the regulations to be in compliance with what actually works from a business sense. I can promise you with this wonderful team we have here at GLA, we're in constant contact with the regulatory bodies. We're up to date on these items. We're in a position to advise you as things change, because it's going to be a constant change. You're going to see changes and rechanges over the next 2-3 years. So stay tuned with us. We'll keep you up to date, and we're always available afterwards to continue the discussions. And I just want to thank you for attending, and hope to hear from all of you soon. Thank you very much. I think we're going to sign off now.